The next witness is Bennett Gershman, a professor of law at Pace Law School. Mr. Gershman.
I'm Bennett Gershman, and the outset I just want to thank this commission for allowing me to make a few comments on a subject that might be a little bit different from the subjects that you're listening to today, and that's the subject of the discipline of prosecutors. Prosecutors are lawyers, as we know, and they're the most powerful lawyers in our society. Prosecutors have the power to take away a person's liberty, take away a person's life. Those jurisdictions that have capital punishment, fortunately New York abolished it, but prosecutors can still put people in jail for the rest of their lives here, destroy people's reputations. And I would say that most prosecutors exercise their powers with distinction, responsibly, professionally, carefully. I was a prosecutor in the city and the state for 10 years, and I can say that my experience has been that most prosecutors are honorable people. Same with judges. Some judges don't follow the rules all the time, and we'd hope that those judges who violate the rules would be subject to some kind of discipline, and they are. But really, actually, prosecutors are not. In point of fact, based on my study of the disciplinary system in this state and around the country. One judge in the Ninth Circuit called prosecutorial misconduct an epidemic. And if you look at the record just this past year in the Brooklyn District Attorney's Office, 14 men were exonerated. Most of them spent more than half their lifetime in jail for crimes they didn't commit. And let me just say that I did a study, I read those cases and other cases. Prosecutors contributed to those wrongful convictions by misconduct. That's a fact. And the National Registry of Exonerations will bear me out. And in fact, New York stands second nationally on the number of exonerations. More than 192 now, given the last exoneration this past week. The only state that tops New York in terms of wrongful convictions is, of course, Texas. Now, my remarks are going to go towards urging this commission to endorse a statewide commission to investigate misconduct by prosecutors. The disciplinary system that we have, and I'm not blaming the disciplinary system, there are all sorts of reasons why the four departments don't investigate and discipline prosecutors effectively. They don't. That's a fact. I'm not going to say anything more than is deficient. Some of my colleagues have used much stronger language to describe it. But I think the disciplinary mechanism, that they're operating in good faith. But first of all, the rules are very, very limited in terms of the model rules that apply to prosecutors. If you use the American standards, ABA standards, that would be a better fit, but we don't use that. 40 years ago this year, the state created a Judicial Conduct Commission, 1975. Previous 100 years, how many judges do you think were disciplined in this state? Around 20. In the last 40 years, somewhere upwards of 900 or maybe even 1,000 judges were disciplined, and several hundred were removed from the bench. Now, prosecutors are lawyers, but prosecutors are different from private lawyers. Prosecutors don't have a client. Most of the rules of professional ethics apply to the private lawyer. We're talking about fees, we're talking about clients, confidentiality, advertising, conflicts of interest, and on and on. Most of those rules don't apply to prosecutors. So there really is a difficulty in disciplining a prosecutor who lies to a judge or suborns perjury or engages in inflammatory rhetoric or hides evidence. I mean, these are hard cases to investigate and prosecute and discipline, and the disciplinary mechanism is strapped in terms of resources, in terms of expertise, all sorts of reasons. And so, given the fact that I think a prosecutor is more like a judge, a prosecutor is considered a quasi-judicial official, a minister of justice. A private lawyer isn't a minister of justice. A private lawyer represents a client. And since a prosecutor, I think, is more like a judge, why not have a statewide commission to investigate and discipline misconduct by prosecutors, and at least weed out those prosecutors who do abuse their function. And there are some that do. They do it egregiously. Really, I can tell you from many cases that I've studied, none of the cases in Brooklyn involving the 14 exonerations, none of those prosecutors were ever disciplined. There's a prosecutor in upstate New York engaged in 6 trials, harshly rebuked by federal and state judges, never disciplined. On and on and on. And so a uniform system to review claims of misconduct by prosecutors, I think is a good thing. I think it will help prosecutors, because I think prosecutors want to know that they have a clean house and they're not being sullied and their reputation is not being tainted by the bad prosecutors. So right now there's legislation for a prosecutor kind of commission. Both houses have reviewed it. It's gone out of committee. I would just like to see this commission endorse the concept of a prosecutor misconduct commission in the same as we've used the judicial conduct commission. I think it's a good thing. I think its time has come, and that's it. That's all I have to say.
All right, thank you, Professor.
Thank you. I have a comment and then I have a question. And the comment is that the New York rules provide, the New York rules of professional conduct have specific rules regarding government lawyers, which also includes conduct of prosecutors. I think that's Rule 2.8. One of the suggestions you have is to have a commission created that would investigate prosecutorial conduct. Are you also suggesting that there should be a set of ethics rules of professional conduct that specifically apply to prosecutors?
Yes, I am. Those rules should be, and they are, codified in the American Bar Association standards for the prosecutor function. And these are hundreds of different subsections of standards dealing with prosecutor ethics. I would ask that this commission adopt the ABA standards for the prosecutor function as its template in doing its investigation and discipline, yes. The ABA standards, yes.
Professor, you've written and spoken about this for a long time. Thank you. Thank you, sir. So you've studied it. The premise of your presentation is that somehow the committees that discipline lawyers are either unable or unwilling to apply appropriate discipline to prosecutors. And so to give you an opportunity beyond speculation about the reasons, which you're free to do you have any evidence from your long-time study that commissions or that is, the disciplinary committees are applying a lesser standard? Are there forces at work that you've been able to identify that establish this premise? I want to give you an opportunity to address that because we're interested.
I think, first of all, from my own personal experience, knowing some of the cases that have not gotten to the disciplinary bodies, I can simply ask why. I know that some disciplinary bodies will not look at a case unless there's a complaint, and complaints against prosecutors sometimes are not that frequent because of the kind of consequences that might happen. I'll just say one thing. Here's my. None of the prosecutors in Brooklyn have ever been disciplined. I know anecdotally of the dearth of public discipline of prosecutors in this state and nationally, and it's been written about a lot. In terms of, has there been a study? There has been a study showing that the rules, the model rules, don't provide a lot of places where the kind of misconduct that prosecutors commit are contained in those rules. For example, You know, there is a rule prosecutors have to serve justice, but that's too nebulous. We don't want prosecutors to embarrass the profession, but that also is nebulous. Yes, there are rules in terms of hiding evidence. Take that rule. That is a clear rule. Prosecutors hiding evidence. But, you know, when you come to think of it, it's a very difficult task for a disciplinary body to investigate. First of all, do they have the expertise to investigate a prosecutor who hides evidence? I can tell you that even in the most egregious cases, prosecutors will say, it was inadvertent, it was careless, I didn't mean it, it certainly wasn't deliberate. That was what the prosecutors said in the prosecution of the late Senator Ted Stevens. And how do you overcome that? How do you prove that a prosecutor acted culpably with a willful intent to deliberately hide evidence?
All right, let me follow up on that. Let's say a lawyer complains, a lawyer who's tried a case against the prosecutor and thinks the prosecutor has hidden evidence and makes a complaint to the disciplinary committee, and the committee thinks it worthy of investigating. Do the committees have access under current rules to all the information they need? Can they, for example, subpoena witnesses in the district attorney's office? Can they get the files? Can they see what was in the prosecutor's files? Can they question the comrade or colleague in the office next door? You know, were you discussing this evidence a month before the trial? What did the prosecutors say? They were going to reveal it. They weren't going to reveal it. I mean, subject to privilege and all that. But are the tools there in the discipline?
I would say the tools are there in the same way that they're there to discipline any lawyer.
DA say, we're not going to give you our files and we don't have to.
And they might plead confidentiality, they might plead work product, there might be a lot of reasons why government files might be exempt from disclosure. Those would be reasons that would stymie a good faith disciplinary body in seeking to conduct this investigation.
So
yes,
wouldn't we need to consider that along with appropriate procedures?
But in the same way that the Judicial Conduct Commission is doing its work and is able to subpoena documents, is able to question witnesses, I would say the same rules should apply to prosecutors.
Thank you.
Just one question regarding that. Where do you find the potential for the conflict, if there is a conflict, between, let's say, the post-conviction relief that a defendant may seek and the complaint before a disciplinary or investigatory disciplinary body? How do you see the, you know, should the complaint before the investigative body wait finality of some post-conviction relief?
I would say it should. I would say that if there is ongoing post-conviction litigation, it should await the finality of that. Yeah.
Yes, Mr. Morton.
Professor, thank you for your testimony. If you would, share with me your thoughts on the situation where a finding of prosecutorial misconduct has been made by a court within the context of a criminal proceeding. The Appellate Division on appeal finds prosecutorial misconduct or on a 440 motion before trial court. Would such a finding be entitled to some sort of collateral estoppel effect before a disciplinary body?
No, it would not. It may be the precursor to a disciplinary body conducting an investigation when they're alerted to a judge, a court, finding misconduct. I will say this. There was a recent decision by the Court of Appeals, People against Wright, last month, where the prosecutor lied to the jury, lied to the judge, said there was DNA evidence when there wasn't. The defendant was convicted of murder. The Court of Appeals reversed the conviction, and the prosecutor was found to have engaged in egregious misconduct. I mean, saying that there's DNA evidence when there isn't. How do you get around that one? I will bet anybody in this room that this prosecutor is never disciplined. Even though the Court of Appeals and the Appellate Division said that the prosecutor committed misconduct. So, I mean, to me, that would alert a disciplinary body to conduct an investigation, however limited that investigation might be. And I know that there are private censures of prosecutors. I've seen that. I've talked to some disciplinary people over the years. And the private censure, we don't know about it, but it's there for some prosecutors. They do that. I mean, I would hope that prosecutors' offices take the responsibility themselves of disciplining their own errant prosecutors. But sadly, they don't. They don't, and that's why there needs to be a disciplinary mechanism to do what the prosecutors themselves aren't doing.